Hello everyone, my name is Wylie, and I would like to inform you about a certain Supreme Court case that has changed the protection and privacy of our emails. This case was known as United States versus Microsoft. In 2013, the US government addressed a search and seize warrant to Microsoft to get the information of a particular user. That user's data is stored in one of Microsoft's servers in Dublin, Ireland. Microsoft disclosed any other communications with the government and requested the magistrate judge to quash the warrant out of respect for that user's data. The magistrate judge denies the request, saying that the Stored Communications Act, or SCA, authorizes the district court to create a warrant for data that is stored on servers abroad. What is the Stored Communications Act? It was an act created to amend the Electronic Communications Privacy Act, or ECPA, to create protection similar to the Fourth Amendment for digital information. Microsoft appealed to the Second District Court, who overturned the previous court's decision. The case rose to the Supreme Court on February 27, 2018. While the decision of the case was pending, Congress and the President signed into law the Clarifying Lawful Overseas Use of Data Act, or the Cloud Act. This makes all internet service providers, such as Outlook and Gmail, disclose almost all information in their custody, control, or possession when addressed with a warrant for it. This ended the dispute between the US and Microsoft, and the case became moot. The Cloud Act gives the FBI authority as well. If they send a letter requesting it, internet service providers are required to hand over almost all non-content records they have to the FBI. The Cloud Act also grants the President the authority to make executive agreements with foreign governments and be able to receive information from their country's internet service providers. This will also grant the other country's government the authority to receive information from US internet service providers. We no longer have the right to protect our emails thanks to the Cloud Act. Before the Cloud Act was created, federal courts would have to rule based on how they interpreted the SCA. Some courts ruled in favor of the people's protection, saying that the SCA creates Fourth Amendment-like protection for people's emails. Other courts, however, ruled that when a user signs up for an internet service provider, the user gives those protective rights to the providers, meaning it is up to the providers if they want to protect your emails or not to the user. Now, with the Cloud Act in effect, protection of people's emails is strictly up to the providers. Thank you for watching. Our government, and even foreign governments, are granted access to all of our emails because of the Cloud Act, and we don't even have the right to protect them. I hope this helps you understand why we need to amend the Fourth Amendment to account for digital information.